It will be available on the Prescott HR YouTube channel probably tomorrow. So, good morning. Thank you for joining us for HR and Coffee. Really excited to talk about Maryland paid family leave. Just kidding. I'm not really excited about it, but at the end of the day, we have to talk about it. So, that's what we're going to do, right? So, today I am joined by Morgan Harried. She's an employment attorney at Gordon Feinblatt. I keep wanting to call it Morgan Feinblatt. I am trying to give this woman a whole law firm. I keep doing it. So, good morning, Morgan.
Good morning. So happy to see you all. Hope you're awake
Yeah,
because you're going to have
that's
to
why we
be
have
locked in
this.
soon.
Yeah, put your seatbelt on because this conversation is going to be fast moving and probably not as much fun as I like to have. And also, it's coffee. It's HR and coffee today, not HR and cocktails. So then there's that, right? So, good morning again. Before we get started, I do have to give a disclaimer that nothing that we present today is intended to be used for legal advice. This is for information purposes only, and any conversation that questions that Morgan may answer does not constitute any type of attorney-client relationship. So there's us when we actually were awake and after coffee. So I'm Kimberly Prescott. Again, I am the president and founder of Prescott HR. And then we have Morgan Harried. She is, again, an employment attorney at Gordon Feinblatt LLC. I did add the LLC to it, as you see, because I did not have it before. So there you go. So today we're going to talk about Maryland paid family leave. And I think that it's really important to note as we go through this that what we're going to talk about today is some of the fundamentals of the regulation, but also some key things that are important to understand. Some of the things that you may have heard, whether you went to Maryland paid family leave's website or just may have heard in general, is that it's like FMLA, but it's paid, and other things that you may have heard. We are going to help you understand some things that are similar there, but the reality is that there's not a lot of things that are similar, right? There are actually more things that are different, and it's important to understand those things as you are supporting your organizations. So understanding that there is going to be some administrative complexity related to it, and that there's going to be the layering of any current leave policies that you may have. If you are an FMLA eligible employer, the interplay of that, how any paid leave that you may offer in your organization may be impacted by it as well. And then understanding that people are going to be eligible to take this leave much sooner than they would have if it was FMLA. So planning for that and the operational impact, having the conversations with employees about this new law, the deductions that will come along with it. Again, any type of overlap that would come with that. So we're going to talk through that, and we're going to go through this relatively quickly. Just from a housekeeping perspective, please feel free to put any questions that you may have in the chat, and we will get to them as we can, but we'll also leave a few minutes at the end for some Q&A, okay? So, Morgan, I don't remember if I was supposed to take this one or not. Is this my slide?
No, I'm going to start now.
That's
I
right.
want to
There you
talk to
go.
them.
All right, there you
All
go.
right. So what is paid family leave in Maryland? So it took a while for it to implement. It was delayed, but Maryland's Time to Care Act establishes a state-administered paid family and medical leave program. And it's funded through employer and employee payroll contributions. And so employers and employees will be paying 50-50 of a 0.9% contribution rate to the state. And then the state will use that as they characterize a trust fund to then pay out to employees that are eligible to take that leave. And so it's a partial wage replacement up to $1,000 per week after you apply and are considered to be qualified to take that leave. And it could be for various reasons, kind of similar to FEMLA, including caring for a new child, a serious health condition, or a covered family member. And so that's up to 12 weeks for a personal condition, but it could be up to 24 weeks if there is the pregnancy related condition, including plus another qualifying event. And so again, that is benefits paid by the state of Maryland, but you pay to the state of Maryland, who then pays out to the qualifying employees.
So, who is covered? From the perspective of multi-state employers, it would be your Maryland employees only. So, employees who perform work in Maryland. And I think this is just an important point in general that employment laws typically apply to where the work is performed. So for this particular law, if you, just because you're a Maryland-based employer, if you have employees that are performing work, let's say remote employee who's in, I'll say Pennsylvania, because that's a real example for me, that lives and performs work in Pennsylvania, that employee would not have the deduction. That employee would not be eligible for Maryland paid leave, even though you are a Maryland-based employer, because it doesn't matter where the employer is based, it matters where the work is performed. So that's going to be something that's going to be important for employers. So I don't know if in your payroll systems you have people broken out by location, but those are going to be some of the things that you're going to have to consider, because you only take the deduction out for employees who are performing work in Maryland. So you will have to identify those as you are starting to do the deductions in January.
Okay, so this is a side-by-side of Maryland paid family leave versus FMLA. And so you see the pay status, Maryland leave is going to be paid with that partial wage replacement up to $1,000 per week. FEMLA is unpaid, but both are job protected. There's eligibility timing. So you are eligible day one with your current employer. Now, the number of hours, you'll see that. And so it's 12 months of service for FEMLA. For the hours requirement, it's 680 hours worked in Maryland. So you see it's not with that particular employer. It's if they've been working within the for that first year for implementation, the state is going to look at each quarter, so the 4 quarters, and then it'll look at a full year. So if it's 680 hours worked in Maryland, for in that time frame beforehand, before they worked for you, then they qualify. 1250 under FEMLA with you as the employer. So an employee could be brand new and come to work for you and be eligible day one if they had been employed in Maryland before you. In terms of the family member scope, there is a broader definition of who qualifies as a family member, which we'll cover on a later slide. It is a narrower definition under FEMLA. It is administered by the state of Maryland versus the federal government. And the primary purpose for the Maryland paid family leave is the wage replacement benefit. And the primary purpose for FEMLA is the job protection, but you do have a job protection component for Maryland paid family leave. And so because the employee doesn't have to work for you for 1,250 hours before they're eligible, that means that an employee could qualify for time to care leave before they qualify for FEMLA. So those leaves may not run concurrently, and employees could potentially access both separately. Although if they do qualify for both, they do run concurrently, but that's just something to keep in mind.
Okay, thank you. Great. So let's look at, this is one of the things that I think is really important to know. I will tell you that I have been advocating very hard to get an amendment on this, and my hope is that we will be able to do it before individuals are able to take leave in 2028. But currently, as Morgan stated, Maryland paid family leave, you are eligible if you work 680 hours in the state, period. So that's something that's really important to note. So it's not a current employer rule. It is whether they work in the state. So they could come to you having worked for another employer in the state of Maryland, and they would be eligible for leave. So that's really important to know. It's not like FMLA where they have to have worked for you for at least a year, at least 1,250 hours. So there's planning that you will need to have in place and contingency plans for if someone can go out on leave as soon as they start for you. And that's going to cause some real operational planning in order for you to manage that type of leave. Because currently, if you're FMLA eligible employer, you don't have to. But you know that you have a year before that person is eligible for job protected leave. Now, if that person comes to you and they've worked in the state of Maryland, they are going to be eligible when they come to you.
Kimberly, I was just going to take a second to address some of the questions in the chat.
Mm-hmm.
Okay. So Nakia asked, how or who identifies the hours worked? So the employers will be responsible for submitting a quarterly report to the state, and that will determine, eligibility, but also how many hours have been worked. And so with all of the employers that are submitting, those reports, so even if an employee leaves and goes somewhere else, the state will be able to access those reports to be able to determine whether there have been 680 hours already in service. When a claim is submitted, the state will also notify employers that a claim has been submitted. So you will be able to provide rebuttal evidence if there is any type of discrepancy related to hours or anything like that. If employees are remote but work for the Maryland-based company and the work is only done for the Maryland-based company, would they get coverage? Kind of depends. Okay, I see that you answered, if they work outside, if they work outside of Maryland, so if they're remote and work outside of Maryland, they're not eligible. If for some reason they live in Maryland or qualify for the localization rules otherwise, then they do qualify. I think that answers Sherry's question as well.
Yeah, I think that there's a little bit of confusion. We may not be able to clear all of it up right now, but one of the things that someone said is so when you set up a SUI account for someone, depending on where you live in reciprocity, you can set, particularly Maryland, DC, and Virginia, there's reciprocity for certain things. So you can set up an account. It doesn't necessarily mean that the person's going to be covered by employment laws per se. So SUI eligibility and employment law eligibility are not necessarily tied together. So in the regulation, it says that employees that perform work in Maryland, that's what the regulation says. There are some FAQs that the state of Maryland has as it relates to those that are eligible. So I would say that, and I will also say that the Maryland FAMLI is still continuing to put out guidance, regulatory guidance. They are not done with all of the regulatory guidance. So, and I don't believe that they've released 5 chapters of guidance, and I don't believe right now that those chapters have specifically spoken to that. But that is something that they are continuing to give clarification on. But currently, it's employees who perform work in Maryland. So again, if you live and work in Pennsylvania, you are considered a Pennsylvania employee for the purposes of employment law. So you would be eligible for any leave that Pennsylvania provides. And that's typically how that works. But again, we'll get additional guidance from the family department on who they deem to be qualified. But typically, it's where the work is performed, meaning where the person is physically performing the work.
In response to Renee, this is separate from your unemployment tax. They use some of the same guidelines for qualification as unemployment, but they do treat it as a separate thing. And Christina, there's going to be an account that you'll have to open with the state that's purely related to family, and it will go there. So it is a separate portal, but if you're using your payroll provider, they are going to design the website in mind to work with third parties, so your payroll provider may be able to do it on your behalf if they do it correctly. All right, so
Definitely
related,
get those things as well.
yeah. Related to the broader family member definition. So this is one of the most operationally significant differences from FAMLA. Who actually qualifies to be a covered family member. So it's extended family, including siblings, grandparents, children, and other relatives that aren't covered under FEMLA. And so that includes step, half, adopted, all of those kinds of folks. Domestic partners, so partners in a committed relationship, regardless of marital or legal status, and close relationships. So individuals with close family-like relationships, even if they're not legally related. So as an example, if an employee were to take Maryland paid family leave to care for a grandparent, that leave may not qualify under FEMLA, but it could qualify under Maryland law, which means that the employee would not exhaust any of their FEMLA leave to be able to care for that individual.
Okay. Right. So here's the challenge that the broader definition of family member creates. And this is another thing that I've been advocating for. So my sincerest hope is that we will get some adjustment to this. So if someone takes leave, so two things. An individual could be eligible to take Maryland paid family leave for whatever reason they need to take it for once they've hit 680 hours with any employer. Now, if you are an FMLA eligible employer, that person does not become eligible for FMLA until 1,250 hours, which means that any leave that they took prior to their FMLA eligibility does not count toward their FMLA entitlement, right? The other thing is if they take leave for a reason that is not an FMLA eligible reason, such as grandparent, aunt, cousin, right? Then that does not overlap with their FMLA entitlement, which means if I take, leave for my cousin, I could then, if something happened with my child or my spouse, I could then take leave again because my FMLA entitlement was not triggered and I took a leave for a non-FMLA qualifying reason. And it's important to note that while there is a real campaign that the Maryland Department of Labor has that it's just like FMLA, it is not. There are going to be reasons that someone is going to be eligible for Maryland paid family leave that does not trigger their entitlement for FMLA, and it does not allow them to not use FMLA after the fact. Yes, Nakia, I agree. So it's important to really understand how it does not run concurrent in every instance. In many instances, it will not. So red flags, I said there's 5. I mean, in my mind, there's probably 15, but we don't have time for that. So I will let Morgan start with the first.
Yeah. And so we've talked about this for most of our time together. Treating Maryland leave and FEMLA as interchangeable, that's a recipe for failure. it doesn't count necessarily against both leave entitlements simultaneously. There are different eligibility rules, different covered family members, different purposes. Sometimes they'll run concurrently, but not always. So assuming that the leaves run concurrently may lead to errors in tracking, potential interference with employee rights and significant legal exposure, possibilities for penalties, all that stuff. It tends to just snowball once you try to get it right on the front end. What is it? Measure twice, cut once. You just gotta make sure that you're on top of it, because every leave situation, it's not a one size fits all. It does require an individual analysis under both frameworks.
And honestly, if you're familiar with California, you kind of have to look at similar to the analysis that you have to do with California. You're going to have to do a similar analysis in Maryland as well. So it is going to be imperative, particularly for employers that are under 50, because you are not used to, and your managers are not used to managing a mandatory job protected leave process, right? So you are going to have to train your managers and make sure that they understand what to listen out for. As is the case with any employment law, a person doesn't have to say, I need to take leave under Maryland paid family leave. If they say, my cousin is having surgery and I'm their primary caretaker, your manager's ears need to be tuned to, let me hand this over to HR. That sounds like something that they need to know about, right? So that you can start whatever process it is or advise the person that, this is the process. Because it's not administered by the employer, you wouldn't necessarily have any documentation that you would need to provide to them. But as the employer, we do have a responsibility to provide postings, and we do have a responsibility to make sure that people know what the process is. It's also going to be imperative that you have a tracking strategy. Again, you're going to be managing Maryland Safe and Sick Leave, your internal PTO policy, FMLA if you're an FMLA eligible employer, and now Maryland Paid Family Leave. So you're going to need to make sure that you have a good way to track those leaves so that you can show that you have not violated anyone's right to any of the leaves that they're eligible for. So it's going to be very important, that you know the difference between them, what triggers a different type of leave, and how to track them and when they overlap. So it's going to be really important to really understand those things.
And we're not focused on this today, but I always have to take this time to say, if you're not tracking your Maryland Healthy Working Families Act leave, please do that. You need to track that leave, make it available to your employees on the front end so that we can keep the DOL at bay. All right, so two more, not budgeting and poor communication. So not budgeting is related to not budgeting for disruption. And this is particularly true for our leaner staffs, our smaller employers. This law will directly impact staffing, coverage schedules, productivity, overtime costs, and recruitment. And operational planning needs to begin now and not after the first wave of leave requests arrive. So you want to take a look at your handbook. You want to take a look at what leave you already offer. You want to look at the intersectionality of the leave that you offer and how that interacts with family leave, because there are some areas where there's a Q&A. As recently as April of this year, they released more FAQs because people just have a lot of questions, and some of it the state doesn't explicitly say that. They're like, well, this is what family offers. Just look at your policy and see, what the implications are. Good luck. And so that's going to be on you to figure it out, because it'll come to a point where an employee will know what they're entitled to. Will say, well, I'm entitled to this, you offer this, so I get to take both things. And that's not the time to backpedal. also poor employee communication. So employees will hear partial or inaccurate information online and from coworkers. So organizations need clear and consistent messaging delivered proactively, including updated policies, manager talking points, FAQs, HR guidance. Before confusion sets in, the state does mandate that there's conversations or communication about contributions at certain intervals, including upon hiring, 6 months before those benefits are available, and there's a few other points where they've outlined where they want employers to speak with their employees about the benefits and eligibility.
Yeah, and they are going to provide us with a document to provide employees because deductions will start coming out in January. I believe they said that we will get the documentation that we're supposed to provide to employees in July. I know Paige is on here, so can we waive making we can talk about that. No, we can't waive making contributions. I'll talk about that. But I know that we're supposed to get the guidance on, I think in July, and the documentation and postings that we're supposed to provide to the employees, but they are supposed to be providing us with posters, communications, and everything that we need to give to the employees with all the information that we need. Really quickly, one thing that we didn't talk about, which I don't know why it's not in this presentation, but we did briefly say there's the 0.9% contribution. It is split between employee and employer in the event that the employer has more than 15 employees. So 15 or more, the employer pays 0.45, the employee pays 0.45, right? The employer can opt to pay the entire amount if they want to, right? They could say, want to pass this on to my employees, pay the whole amount. For employers that are less than 15 employees, the employer does not have to pay a contribution, but the employee does. So in every instance, the employee has a responsibility to contribute unless the employer decides to make that contribution for them. There are some ways that employers can opt out and get their own plan. The details on that, quite honestly, are the self-insured plan, where you have to show the state that your plan is richer, better, and approved. I will be honest with you, that's a lot of the guidelines that they've dropped included what it takes to make that happen. But the reality is that in practice, it will be very difficult for employers to meet the threshold to show that whatever plan they put in place qualifies and is approved for them to opt out of the state plan. And I think we'll get to a point where we will talk about the fact that if you decide to opt into the state plan, you're stuck there until until the next year, and then you have to pay penalties. I think we'll talk about that. But the operational reality under this new law, some things to consider. You will probably have more leave requests. There is going to be more complexity. There's going to be a greater need for consistency. I know, particularly in smaller organizations, a lot of times there's exceptions. It's like, oh, this person needs this person has that. But it's going to be a greater need for consistency because you are going to be managing multiple types of leave. And then there's definitely going to be more administration. So the coordination, the tracking, the documentation, making sure that you have all of those things. That's something that, is going to be our new reality for Maryland employers. So questions employers should be asking right now.
Yeah. So these are logistical. Who will administer the leave internally? Is your HR equipped to handle the increased volume, or do you need external support? Can you ask your HRIS track multiple leave types? You'll need to track Maryland leave, FAMLA, PTO, disability, and intermittent leave simultaneously? So can your system track multiple leave types? Is your payroll system ready? Can it handle contribution tracking, deductions, and coordination with state benefit payments? And how will you train your managers? So managers will need to know what to say and what not to say when employees ask about leave. And, we'll consider the managers to be kind of the front line of, speaking with employees. And so uh, some of those notification requirements, when an employer knows that an employee needs to take qualifying leave, that's one of those times that it's triggered to inform the employee about their eligibility for benefits, or at least that it's an option. And so the employer is deemed notified when someone like a manager is aware that an employee needs to take leave. So it may not be the magic word of, oh, I need to take family leave or I need parental leave. It could be, I'm having a baby, or I can't, get around because I'm pregnant, or my mother fell and I need to go care for her. It's going to be some of those other things. So being able to issue spot, as they call it in the legal world, but also just having those tools to be able to interact pretty seamlessly, and also in conjunction with what your policy actually says and what the state law requires.
Okay. There was a question where someone said, when is an occurrence where all three could be used? If an employee is at a 50+ employer and they give birth, they would be qualified for Maryland leave, FMLA, and short-term disability at the same time, as long as their organization offers short-term disability. So that would be one example, but there could be others. All right. So one thing to note as well, the payroll system piece, it is really important. As you all know, we are an HR consulting firm, and we work with a lot of clients, and we work with different types of payroll systems all the time. And they're not all created equal. Okay. I think we all know that, right? But it is really important to make sure that today, May 27th, you start asking your payroll company if they are ready. Don't get me wrong. And when you said Time to Care Act, Morgan, that took me back to a really dark place when this all first started. I forgot all about that. But yes, we have been talking about this since it was called the Time to Care Act, and it has gotten pushed and delayed and delayed. But that doesn't mean that your payroll company is ready for it. Very important to really outline, have those straightforward questions with your payroll company. Are you ready for Maryland paid family leave, first pay period in January? Do I have to add that deduction code? Is it a deduction code that will already be set up for me just to add my number? Like, you really need to ask those questions today. Because it's going to be important for you to know if you need to make a change. If your payroll company is like, well, we're not ready, it's coming down the pike, we need to figure some things out, it's on you. Your payroll company is not going to be responsible to the state of Maryland if you don't take these deductions out and report these wages the way you're supposed to. I will say that one of the payroll companies that we work with, Paylocity, they are ready. They're ready today. But I know that that's one of them. I know there are others that have it as well, but I know specifically that they do. But it's important to make sure that you ask that question literally today. When we get off of here in 15 minutes, reach out to them. Some other questions that you need to ask is, how will you coordinate your leave approval? So who will approve them? Who will document it? Who will communicate with the state and the employee? So basically, when you register with the state, who is the point of contact, and making sure that that point of contact remains up to date with the state, so that if someone takes leave, the right person is being contacted. Because now, one of the other things to note is that because the process does not start with you as the employer, your employee, while they should, and the DOL says that they are required to let you know that they're going to take leave, they may just go to the state first. The first time you hear about it may be when you get your documentation from the state. So it's important to make sure that the point of contact with the state is always up to date. The other question that you should be asking yourself is, are your attendance policies aligned? So you need to make sure that your attendance policies account for protected leave. So, you can't necessarily have these policies that say things like, any leave that's not approved in advance will be immediate, X, Y, or Z, because at the end of the day, there could be a couple of day gap between when you get communication from the state and become aware. So you need to look at your policies and really think about the practical application of how this is going to work, because you are not administering this leave and or the request for leave, and how that aligns with your policies. You do need to ask yourself, how will you handle intermittent leave? I did see in the comments, someone asked about intermittent leave. Yes, intermittent leave is available, and you will need to handle it by tracking it. There's a certain number of hours that individuals are eligible for paid family leave, Maryland paid family leave, and you'll need to track how many hours they've used. Another thing to note is that the wage reports that are sent to the state are quarterly, and some of the reporting that goes to the state is quarterly. So one of the things that we have to make sure that we get some clarification on from the Family Leave Department is, how are they tracking the entitlement to intermittent leave? So that is a point of clarification that we're going to need to get from them before this goes into effect. Keep in mind, people are not going to be able to actually take leave until January of 28. So we have a little bit of time to continue to get some of this clarification, but it's really important for people to understand. And then what happens if multiple employees are out simultaneously? You need to plan for that. You need to plan for that. So that's where we talked about in the beginning, making sure that you are thinking operationally about planning and having contingency plans for if you have multiple people out at the same time.
So I'm typing in the chat.
It's okay.
All right. So looking at the practical preparation steps, these are the immediate action items that every Maryland employer should be moving on now. And that's regardless of the organization size or industry. So you want to look at those leave policies and audit all of your existing leave policies for gaps, conflicts, and necessary updates. Look at it, really think critically about it. Look at it with a trusted professional to see how those two things intersect, and that you really looked at, how those two things may run concurrently or consecutively or intermittently, and all of the possibilities. Audit attendance practices, ensure that your current attendance tracking and disciplinary practices won't create liability, and if they do, then make those shifts. Meet with payroll vendors, confirm your payroll provider is ready and prepared to do the contribution tracking and reporting, and evaluate your manager training and identify any training gaps and develop scripts, FAQs, and escalation protocols. And you want to do that before any of those situations arise so that you're prepared.
Yes. Thank you. Great. So then you also want to, again, update any handbook language. You will need to add Maryland paid family leave language to your handbook at some point. Quite honestly, even though they're not eligible for leave until 2028, the deductions are going to happen. So you need to work with if you're the HR department or your attorney, to determine when you want to add that policy language in there. You want to designate someone in your organization to be responsible for leave administration. At the end of the day, now, as a Maryland employer, regardless of your size, at a minimum, you have safe and sick leave and now paid family leave. At a minimum, there are other things that you need to manage, but those are things that are going to require you to have someone who understands the regulations to manage leave administration. You also need to develop a communication plan, the communicating cadence. So even though we don't necessarily have like some of the documentation requirements that some other states have around communicating wage changes and things like that, you're still going to have to come up with a cadence at which you are going to be communicating this deduction and when they'll be able to take leave, particularly leading up to January, because just changing your posters is not going to be enough in the beginning. And then you want to make sure that your managers are trained, that they understand the keywords, the buzzwords, and when to pass that on to whoever is responsible for leave administration.
So the official Maryland employer guidance, there's specific employer guidance that the Department of Labor has published, including resources to assist with the implementation planning. And employers should review these materials as part of their compliance preparation, straight from the horse's mouth, as we'll call it. So what you'll find, so the contribution rate information and calculation guidance, employer registration requirements, notice and posting obligations, private plan exemption details, employer portal access and instructions, which is not available yet, but coming soon, access to the official guidance. You can look at this link right here below. But the official Maryland Paid Family Leave Employer Resource page is maintained by the Maryland Department of Labor and updated as implementation guidance evolves. And they put, a nice little caveat on their stuff, that things are based on their current thinking. They do not want you to tie them to anything just yet. They are working on it. This is very ambitious. They're figuring it out as we're figuring it out. That's my impression. So continue to pay attention. Like I said, the FAQs, they updated those as recently as last month. So another 5 pages of FAQs. The resources are there, but it may take a little bit of effort to demystify it a little bit too.
Yes. So thank you. Thank you. So there are still questions in the chat about eligible employees and who's a Maryland employee and who's not. Again, the state that the person, where you have their unemployment coming out of, again, those are going to be two separate things. Granted, the DOL manages unemployment and the DOL manages paid family leave, but there are times when employers have just paid into Maryland unemployment, and if the person lives in Pennsylvania, they're like, you'll just need to file your unemployment in Maryland. However, as it relates to this particularly, because it is a fund that employers are paying into and employees are paying into on a grander scale, it is a little bit more specific and managed in a more specific way. I will say that some of the guidance is not as clear yet as we want it to be, right? But from what I have read and understand is it's where the person, if they are a Maryland employee, right? And they perform work in Maryland. So if I am a Maryland employee that performs work in Maryland, then I am eligible. I will need to double check and you can tell me, Morgan, as it relates to if I am a Maryland employee and I go to Pennsylvania and perform work every day. It is my understanding that I'm still considered a Maryland employee. But you tell me what your
so if you live in Maryland
mm-hmm.
and you go to PA to perform work,
mm-hmm.
where's the employer based? PA?
Yes,
then you're a PA employee.
right. That's what I mean, again, that was my understanding. It was where the work is performed, not necessarily where the person lives. But there seems to be a lot of questions, particularly around where people file unemployment. Those two things are not tied together. And so I think we just need to separate those things. Again, it is typically where the work is performed, not necessarily where the person lives, not necessarily where the company is based. It's where the work is performed. So I think that those things need to be separated. But that is something that, again, I know that once we get the full regs, then
Yeah.
we will get more clarification
But it's
on.
it's important to know that the state is using that as the shorthand, that if you qualify for those unemployment insurance benefits, then you likely qualify for family. So they're going to hold people to that, even if it's not. So it's like it's important to be mindful that that's the current thought process.
Yes, it's the current thought process. However, what we know from a practical matter
Hmm.
is that the way that people set people up in payroll
Hmm.
for unemployment does not always have any rhyme or reason.
Sure,
So
sure.
I think that it's important to note that as well, right?
Yeah. Yes.
But I also know in having conversations with individuals, both in the General Assembly and in family, is that there is a recognition that this is very convoluted and that there are a lot of things that they need to do a better job of clarifying and putting a pin on. So, to Morgan's point, that is their understanding as of today. But when it goes into practice and application in January of 2028,
They're gonna
my
see.
gut tells
They're
me,
gonna see where the
yeah,
holes are.
my gut tells me it's not going to look like this presentation today. But this is where we are today. This is what we have to start communicating as of July of this year for deductions that will start coming out in January of 27. All right. So again, as we start to wrap this up, this is more than just a compliance issue. It's really about workforce planning because that person being able to go out as early as their first day, if they've worked in the state of Maryland, is going to be something that employers will need to really plan for. From an operations perspective, there could potentially be an increased volume of people going out on leave. You really do need to train your managers and make sure that they're clear and they understand. And then you want to make sure that as you communicate this, particularly the deductions and the message about leave and how it will be managed inside the organization is clear so that you can retain culture and employees. Day one means they could be day one when you hire someone. So someone once the leave starts. So this is after January 2028. Day one that someone comes, if they work 680 hours in Maryland at all, they could say, I need to go out tomorrow for my grandmother. That could happen because they are considered an eligible employee because there is currently no per employer service requirement. So I hope that that clarifies it.
So for what was the point of today? What should you take with you? Uh, why did we wake up so early to talk about all of this wonderful stuff? The employers who will navigate Maryland paid family leave most successfully are the ones who start preparing now, not after the first leave request lands on their desk. So just remember that Maryland leave and FEMLA are not the same thing. There's different eligibility, different family definitions, different purposes, and they will not always run concurrently. Day one eligibility changes everything. You're not waiting the 1,250 hours of work. It could be if they came from somewhere else and have already worked in that 680 hours, they could be eligible for this leave walking right through your door. So new employees may be eligible almost immediately. And so your operational planning needs to reflect that reality. Preparation is a competitive advantage. Organizations that prepare early will reduce legal risk, improve consistency, and protect the employee experience. Be clear, communicate clearly about your policies, think strategically about how you want to all of this to intersect. And we'll figure it out later is the highest risk strategy. The complexity of this law rewards organizations that act now and will actually punish those who wait. So if you have questions, you can contact Kimberly at Prescott HR, or you can contact me. I'm at Gordon Feinblatt, LLC. I'm in Harbor East, representing employers for personalized guidance on your organization's readiness.
Thank you so much. Thank you all for being so engaged and staying on. I know that this is a fun but not so fun topic, but it's important that we understand it, right? We did get another question. Will family be collecting and substantiate? Yes. So all documentation for paid family leave will go through the Department of Labor. They will review it. They will substantiate it. They will determine whether or not the person is eligible for leave. They will pay the person. It's in the administration aspect of it. It is supposed to be administered similarly to unemployment, which is why DOL has it. So they will do all of it. They will make the payments. They'll look at the reporting and determine who's eligible.
And right now they're advertising a 10-day turnaround from application to a determination, and the employer is to be consulted within that time frame. So it's a pretty quick turnaround.
Yeah, but also we were supposed to get information about all of these things a year ago, and we still don't have it, but neither here nor there. Okay, so anybody have any other questions this morning before we wrap? All right. Yes, thank you. And thank you all for joining us. We definitely appreciate it. Oh, one more question. All right. The private plan, maybe we're considering, although you're, okay, the state will be developed. Yes, they will. They will. And good luck to that. I will say this. You have to pay to apply to have a plan outside of the state of Maryland. If you don't get approved, you don't get your money back for applying. The other thing is that if you and don't start contributing at the beginning of the time frame, you will then have to pay penalties for the period of time that you weren't in it. So yes, it is an option. It may be worth looking into, but there are some considerations that you need to make before you go down that path. Because if you don't get approved, then you're outside looking in, and then you got to pay penalties to get back in. It's kind of like double dutch. So there's that. So yes, we will have a part 2. That is the plan. We plan on having a part 2. Yay. All right. I think, let's see. Yes, it was very, yeah. So thank you all. Definitely appreciate it. I'll send out a follow-up email, like I said, and I will send the slides to the participants. And then this recording will be on our Prescott HR YouTube channel starting probably tomorrow. So thank you all. Hopefully you might need something stronger than coffee after this, but I hope you have a great rest of your day. Bye.
Take care.